Hello, everyone. We are ending the day talking about litigation strategies, which I'm hoping is going to be as riveting as it sounds. Thank you so much for having us. My name is Melloy, and I'll be moderating the panel, and I'm a litigation attorney with the National Immigrant Justice Center in Chicago. Down at the far end of the table is Nazli Mamidova. I didn't get that right. And she's an attorney with Wang Law here in Cincinnati, where she represents immigrant communities in the tri-state area. Next to Nazli is Katie in the middle. Kathleen Kirsch, is an attorney with Advocates for Basic Legal Equality in Dayton, where she represents low-income immigrants in their immigration court proceedings, in civil rights cases and labor cases. And immediately next to Katie is Enid Trucios-Haynes, who is a professor of law and the interim director of the Muhammad Ali Institute of Peace and Justice at the University of Louisville's Brandeis School of Law. So we're really excited to have such a great panel with us today. So today what we're going to be talking about is why litigation and what litigation means. We're going to talk about the different types of litigation and some of the cases that really show kind of what's going on in this new world order of the last year and a half. And we're going to talk about how organizing strategies can intersect with litigation and how litigation can intersect with organizing strategies and how they all work together as one cohesive strategy. So I'm going to put this question out to the panel members. Why is litigation important, period, and why is it important now?
I'm going to take that. So litigation is important, and it is especially important now because it's becoming harder and harder to get the government to do anything or to move on any issues. Sometimes, and we're going to get to that later, people are detained for a prolonged time and government wouldn't release them. So ability to litigate and sue, and that's one of the powers that attorneys hold, that ability becomes very valuable, especially in today's day, because we cannot anymore just resolve an issue with a simple phone call. There's a constant struggle and push.
And I would say often the threat of litigation can be very effective as well to bring the government to the table or other agencies, if you're working with an educational system, for example, just talking about the rights that people have and the understanding that you will pursue litigation can be very effective.
And the one other thing I would add is that when we're talking about litigation versus the immigration court system, which we'll get to on the next slide, the immigration court system, they all answer to Jeff Sessions, and they all are within the administration. When you go into federal court, into litigation, you're going to a different branch of government, and my personal experience is that branch of government is feeling rather emboldened right now. For those of you who follow the news on the various big pieces of litigation, federal judges are not too shy in this current environment. And even those that were appointed by Republican appointees are not too shy to tell the Trump administration that what they're doing is not okay. I think the best example of this right now, and the most recent example of this in the last couple of weeks, is what we're seeing out in the Southern District of California, where a judge is telling the Department of Homeland Security that it needs to put families back together and ordering them to do so. So that's the power of federal judges, is that they can, doesn't matter what the policy is, they can override that policy by saying it's unconstitutional or in violation of the law. So I know we have a mix of lawyers and non-lawyers in the room, so I thought we'd start with something kind of basic, which is we talk about litigation a lot, and what does that actually mean? So Nazli, if you could maybe help me out here. When somebody is put into removal proceedings, where do they go first?
It depends. So normally, if the person put in removal proceedings, and let's assume they don't have previous deportations and any other complicating issues, they would go, they will wait in detention center most of the time for a hearing in front of immigration judge. An immigration judge, as Kate mentioned earlier, is an employee of Department of Justice. And once they get their hearing with immigration judge, which is administrative proceedings, then depending on whether they had the relief granted or not, right? So whether the judge told them they're gonna stay here or not, or they're gonna be deported, then they would go to the next step. And next step is still within the administrative proceedings and will be Board of Immigration Appeals. We do not get to federal court until after we have been done, or that person in removals is done with the process in administrative proceedings, which includes immigration court, discretionary stays by Immigration and Customs Enforcement, and Board of Immigration Appeals.
Yeah, so then when they're done with the Board of Immigration Appeals, and the Board of Immigration Appeals says, yep, you're going to be removed, then that individual can go up to the Circuit Court of Appeals. Here in this area, that's the Sixth Circuit Court of Appeals. At the same time, there's a possibility you could go into federal district courts. And what you see in federal district courts are challenges to agency action in violation of the law and the Constitution. To put that in normal speak, that means suing ICE, suing CBP, and saying what you're doing is not right and is in violation of the law. And those can be either individual actions or they can be class actions. And the class actions are really effective because you're trying to get a change made on behalf of every immigrant in that situation. And so when that happens, you're really affecting a whole-scale policy change as opposed to just getting relief for one individual person. Not to say that that's not exceedingly important, but we're seeing more and more class actions happening in this environment to really try and get those policies and practices to change.
I'm sorry, and I'm gonna add something. So sometimes there is a proceedings where a person is still in immigration court, but we still go to the federal court. For example, if someone was stopped unlawfully, it's illegal arrest, unlawful arrest, and ICE had no reason to stop that person and detain them, there is a possibility of going into federal court and challenging that stop based on Fourth Amendment. So there is ways to use the Constitution in immigration court while people are still going through the immigration proceedings, and there is a ways to maybe sometimes get them out of the detention. So I would say in today's world, don't be afraid to use the Constitution and to use the federal litigation as parallel to the immigration proceedings.
And I think, speaking of the Fourth Amendment, this is kind of fast-forwarding a little bit, but Cincinnati and Louisville and where I'm from in Chicago are all, as I understand it now, sanctuary cities. And there has been a ratcheted up enforcement in those areas, and with that ratcheted up enforcement has come some tactics that might be constitutionally questionable. And so it's really key what Nazli was saying about using these other methods to go into federal court to try and get them to stop doing that. So we're going to talk about just a few of the different types of district court actions and federal court actions very briefly, so you all know what tools are out there. For the immigration practitioners in the room who might not practice in federal court, I think this is our pitch to say, now more than ever, you need to go to federal court because of what we were saying earlier, that judges are really feeling like they are the last stop to controlling some of these practices. So one really effective tool, and I saw some nodding in the audience when I think it was Nazli or Katie mentioned that threatening, or it was Enid, I'm sorry, that mentioned threatening litigation. This is a great piece of litigation to reach out to the government and say, hey, I'm about to file a mandamus or an unreasonable delay action on behalf of my client who's been waiting, 4, 5, 6 years for you to do something on a particular application or petition for a benefit. And oftentimes just reaching out to the agency and saying, can you do something before we have to go into federal court and get in front of a judge to decide this, that will kind of, for lack of a better term, shake that case loose and get it to the top of the pile for them to decide. So this is a really great tool for any cases that are stuck and need to be unstuck. We've used this before with asylum applications that have been delayed, and we're also trying to use this for U visa cases. It's a little bit more tricky in that context, but for anyone that practices in the U visa space, you know that their delays are kind of incredibly long. So those are two areas where you might try using that action. And since we have an administrative law professor here, could you talk with us about the APA?
Well, I used to teach administrative law, and thinking about challenges under the Administrative Procedure Act, some of the issues that come up is it's possible that the DHS, either ICE, CPB, or CIS is acting outside of the mandate, outside of the scope of what the Immigration Nationality Act authorizes. And because the law provides the agency with the general parameters of its action, but then all of the regulations that are passed by each agency to implement the law may themselves be outside of what the agency mandates. So we've seen lawsuits suing the CPB or ICE, arguing that their actions are outside of the scope of the statute. Also, there's another process for changing policy, and that's called notice and comment rulemaking. And so whenever there are major changes in policy, what's required is that there's a publication of the proposed change, the proposed new rule, that's published in the Federal Register. There's a notice and comment period, usually that's 60 to 90 days, in which the public, agencies that have business before the agency that are involved, any agency or group who cares about the issue, and it's a great place for activists and other community organizations to get involved, all of those folks can submit comments that are part of the record that the agency has to consider in adopting its final rules. Now, this has been an issue more recently in terms of changes in policy that CIS is instituting in terms of becoming more of an enforcement agency and passing on declined cases onto ICE. That's a proposed policy, and the question is, that's a new policy, is that outside of the notice and comment process, right? So if there's a requirement for democratic decision making that everyone can be involved in the final rules that an agency adopts, then when an agency acts precipitously without that process, that could be a violation of the notice and comment process. So those are other ways in which community organizations can become involved or to challenge agency action.
Great. And more and more we're seeing clients detained, and Nasli, do you want to tell us about what you can do for a detained client who, as you mentioned earlier, their detention might have become prolonged or is illegal?
Yes, and just to add something that Enid said, sorry, Kate, getting off the track, but there has been a situations here in our Cincinnati local field office where USCIS has called on ICE and put people into detention or removal previously, even before the policy came out. So although we're not in a super hot, so to say, immigration area of where a lot of things are happening, there is a lot of things happening in Midwest also. It's not very uncommon to see that USCIS is, in my personal opinion, is overreaching of what their duties are and what they should be doing and becoming an enforcement agency. Yes, as to the detained clients, what can they do? If the clients are detained and they are alleging that their detention was unlawful, they have two things. They will get most of the time, right? If there's no complicated other issues, they will get the day in front of the immigration judge to review their detention, and hopefully they will get out on a bond, which might be reasonable, might be not. And another issue is to pursue it in a federal court and to question the stop and seizure itself. So once you go into a federal court, you would file should I go into habeas?
Yeah, go ahead.
Okay. You would file a habeas corpus action that's for release from detention. There's several ways you file it, and it's not always for the immediate detention based on the arrest. Sometimes it's for the people who have had order already that ordered them deported, and they finished their deportation proceedings, but government couldn't remove them to another country, and they were walking around for several years. And one day ICE was like, I think now I can get him a travel document and send him back, let's say, to Iraq. And they would detain that person again. And that's where, again, the federal action would come in. Most of the time, the unlawful stops would violate the Constitution for the amendment, and we do bring those in. There are several cases that actually been brought in Cincinnati in our federal Southern District of Ohio. Charleston Wong, another attorney in our firm, he practices appellate practice, and he goes to that court a lot. And we have even had a Bivens action also, and that was in Kentucky, Eastern District of Kentucky. So we're trying to fight the unlawful stops and seizures and arrests, but it's very hard. We also found that a lot of times judges don't really understand immigration, federal judges. So you really have to go an extra mile and explain things to them also.
Yeah, I've heard, for lawyers in the room who might be dipping their toe into federal practice, I've heard federal judges say, just stop with all the acronyms. I don't understand all the acronyms in immigration land. And you really have to walk the judges through, because the federal judges are judges of general jurisdiction, and anyone who's spent any time doing immigration law knows that there's nothing general about this and that it's a very complicated statute. So I always try to make sure that my writing is really clear and concise, because the subject matter is so complex.
Kate, can I say one thing about habeas? So one of the things, I work for ABLE, and we've been doing a lot of work in the responding to the raids in northern Ohio, northeast Ohio, and one of the big things we're hearing from the community is, okay, so this guy's going to get out on bond, and then what? And so a lot of people think, okay, you get apprehended by immigration and you're going to get a bond. And that's not true. There are specific instances where, as Nazli mentioned, the bond either might be prohibitively expensive. We've seen $45,000 bonds before, which for a family that's sometimes twice the family's income for the year. Or they may have committed certain crimes, and therefore they're not eligible. They're under what we call mandatory detention. Or they may have presented themselves at the border, and they were marked as an arriving alien by CB, Customs and Border Protection, and they're not eligible for a bond. Or, as Nazli mentioned, they may have been already ordered removed, and there's no way to get them to their home country. Their home country won't accept them. And so, for example, if in that case, someone who's been here for 6 months and who's already been ordered deported, it's federal case law, Supreme Court case law that says that they should be allowed to leave. So habeas petitions, number one, don't think that everybody who's apprehended by immigration gets a bond. And number two, habeas is a really good remedy for some people who may not be eligible for a bond for whatever reason.
And just to add to that, when you are in immigration court, it's not 10% of the amount. It's a full amount you have to pay to get out. So someone gets $45,000, $50,000, you have to bring that in.
Yeah, which is obviously very, very difficult. And I think that's, we're going to talk about this in a minute, but in terms of organizing strategies for community members, bond funds are really critical right now as more and more people are being detained, and we're seeing certain judges in particular, just the amounts getting higher and higher.
And so once you get out on a bond, or if the habeas been granted and you are released from detention, that does not stop your immigration court proceedings. So you still continue with it.
So if you get an order of removal from the immigration judge and then that's affirmed by the Board of Immigration Appeals, then what happens?
Then you go to the Sixth Circuit federal court, where stays, so you cannot be in United States. That's not automatic. Once you appeal the decision of immigration court to the Board of Immigration Appeals, there's an automatic stay. You get to stay in United States while is decision made on your case. However, once you get to the federal court, Sixth Circuit, there's no such thing. So attorneys have to file for the stay in addition. And there's sometimes situations that we have experienced where your stay would be granted for maybe a month or two, and then they'll revoke the stay and say, all right, well, you can go home and we'll make decision while you're away. So stays on the federal level when you go to Sixth Circuit are not automatic, so don't expect your client to stay in jail or outside of jail if they're released and be here in U.S. until their decision is made.
Great. And then the last type of action we wanted to talk about is actions under the Freedom of Information Act, or FOIA. And FOIAs are really key for not just lawyers and legal organizations, but really for any organization that might have an interest in an issue. You can file a Freedom of Information Act request with a government agency like ICE or CBP or U.S. Citizenship and Immigration Services and ask them for their documents on a particular subject. They have to respond to that within 20 working days, which is essentially a month. And if they don't, if they fail to respond, you can go straight to federal court. Now, if they respond but don't respond with everything, then you can take an appeal within the agency and then go to federal court. Or if they say you don't have a right to these documents, you can again appeal that decision and then go to the federal court. So this is a really powerful tool because you can get into court really fast, and the statute is pretty weighted on the side of releasing documents and releasing information to the public. So again, this is not just for lawyers. If you're a community organization that has an interest in a particular topic and you want to know what does ICE have to say about that and what were their inner policies and inner discussions about that, you can ask the agency. And the other thing I want to talk about, and Katie, feel free to jump in here, is you can also, each state has its own open records laws. And like in Kentucky, for example, they have a 3-day turnaround. So the turnaround is even faster for a lot of the state laws. So I don't know what the experience is here in Ohio, but.
Yeah, Ohio, we have the Public Records Act. So you can make a request under the Public Records Act. You can email it. You can also, if you're interested in doing a FOIA, you can email your FOIAs now, your Freedom of Information Act requests. If you just Google, CBP, Customs and Border Protection FOIA, if you have a question about an apprehension at the border, or if you have a question about an ICE policy, you can Google it, and it's on the ICE's website. It's pretty easy. You just send in an email and then wait. The thing about, I have had some personally not great experiences with FOIA because things we otherwise would litigate. ICE is very, very reluctant to share any information, as well as the other agencies, and so. State agencies sometimes can get you the information you want, and they seem to be, I don't know why, but they seem to give up. I wouldn't say they give up information easily, but it can be a way to get information without having to go to court, and it might be a way to sort of circumnavigate that process. So, like, for example, in Ohio, to answer your question, Kate, it's the Public Records Act request. You can go online to this Ohio, just if you Google that, there's a number you can just call. You can do it over the phone, or you can email it, and we usually get a turnaround within a couple of weeks.
Which is very different than when you send something to ICE.
Another
Yeah.
in immigration time.
And just for those of you who might be interested in immigration detention centers in your community, most of those are run by county jails. And so ICE contracts beds from county jails or local entities. And so that's a really critical way to get information about what's going on in the detention center. Now, sometimes they will refer you to ICE because it says immigration. But if that's something of interest to you, consider sending open records requests under state law to the county detention centers.
Kate, and may I add something? And I really do suggest doing FOIAs, especially for the immigration practitioners who are here. So we found some cases where ICE would be like, oh, this person has a deportation order or removal order previously from 10 years ago. Well, we requested, and they wouldn't have it. So there are situations happen where you might hear something from the agencies. They would tell you one thing, but in reality, it's not. We had recently in Butler County a person who was detained. ICE officer came in and told him that he had been deported previously 4 times. And when we requested his deportation record, they didn't have any.
So you were able to use the absence of records as evidence that the government didn't have a case?
Yes.
Wow, that's amazing.
And I think that's a regular practice, right? So when you're representing a client that you submit a FOIA request, right?
Hopefully it is.
So we're going to talk about a few, now that we've kind of talked about hopefully not totally boring law, we're going to apply these to some real world situations. And Katie's going to tell us a little bit about some of the litigation that her office is handling involving the intersection between federal and state law enforcement, which is a very hot issue and fraught topic.
It is fraught, yes. So at ABLE, we represent people in individual immigration cases, but we also do a lot of what we call impact litigation, which, as Kate mentioned earlier, can be class action. It can be representing a group of people, or it can be representing one person whose case might have an impact on other people in the future. And one of the things, one of the issues that we're really focusing on right now is is the collaboration between local or state law enforcement agencies and immigration. If you listen to the news at all, you've probably heard, the administration is trying to put pressure and persuade law enforcement agencies to essentially do their job for them, right? We know immigration is a federal issue. The federal government has jurisdiction to enforce it. And so one of the cases that we are working on, one of the advocacy areas is is enforcement by Ohio State Highway Patrol of immigration law. We have seen a ton of stops, traffic stops, that we would argue are racially motivated, particularly in the northern half of the state, but they do happen down here in the southern half of the state, where people will be driving and they will either arguably not be committing a traffic violation or commit a very small traffic violation, and they will be stopped. Sometimes Border Patrol is already in the car, which I think gives you a sense of the motive of the stop itself. They will be detained. They will be, the highway patrol trooper will address the traffic issue, no turn signal, following too close, what have you. And then they will proceed, after that stop has sort of been dealt with, to detain them for, varying periods of time, all of which we argue are unlawful, while they wait for immigration to sort of get its act together and get there and take that person away, arrest them, book them, and start processing them and putting them in removal proceedings. And we've had this happen to people who, we've had U.S. citizens detained so that their spouses can be checked, their immigration status can be checked and sitting there and waited. We had a young mother of 3 who was driving with her husband and his nephew on their way to immigration court to attend the the younger brother's hearing. And they were pulled over by a trooper. They were detained for about 45 minutes. She was she was searched, and she was placed in the back of the trooper vehicle with a canine, with a drug-sniffing dog. And she was forced to sit there, and she was not allowed to talk to her husband. Her children were in the back seat crying about why their mommy was being arrested. And she was forced to sit there and watch as Border Patrol came and took her husband away. And we have all of this on video. When she pled to be reunited with her husband, to say goodbye and give him a hug, they didn't allow her to do that. So, and meanwhile, these 3, U.S. citizen children are sitting here watching their mother and father getting arrested for following too close to a vehicle in front of them, for which she never got a ticket. So obviously, there's something wrong with that, right? And so we are filing, and there are a couple of other plaintiffs on that case as well. We have filed a 1983 action in the Northern District of Ohio in the Western Division in the Toledo court. And we're alleging Fourth Amendment violations. We're also alleging equal protection violations. So you can't stop somebody for being Hispanic or Latino or appearing to be so. And that is what we are arguing. And so one of the things that litigation can also be, in some cases, a tool to get information. So we're certainly going to be asking for information about these policies. Why are they working together? Why is Border Patrol in highway patrol vehicles? So that's a way we're trying to get that information. We also are we are conducting advocacy right now with the Bureau of Motor Vehicles. So for those of you who are not from Ohio, that's our DMV, or they are a license issuing agency. We have done quite a few Public Records Act requests, even preceding my time at ABLE, to try to get their policies, and we're currently trying to figure out how to address some policies that disproportionately affect immigrants. So, for example, a policy that if a child, someone under 18, wants to get a driver's license or a state ID, they have to have someone sign for them. And that person has to have documents. And so if you are a U.S. citizen, a green card holder, someone on a visa, or someone, and you're trying to get an identification for yourself, so you are able to do very basic things. We all don't, we take for granted what we use our IDs for every day. If your parents are undocumented, you apparently don't have the right to get an ID. So we're conducting advocacy with them, trying to create better policies that don't disproportionately impact these children whose parents happen to be from another country.
That's great.
Thanks. Do you want me to talk about community partners? I forgot. I apologize.
Sure, yeah, that'd be
Okay,
great.
real quickly. So I know many people in the group are not lawyers, so I think it's really important to talk about how important the non-lawyer community partners have been in these efforts. So the first thing is people have reached out to us and called me, called my co-counsel Emily Brown, called other people, and given us cases, people that they know. There are only a few of us working on who are able to actually litigate these cases at ABLE, and we can't be in the community all the time meeting with people. So what you all see on the ground is extremely important. And so that, I think, has been the biggest source of collaboration that we've had in these particular areas. And then I'll talk more about other collaboration later.
Yeah, and we just filed in Chicago. We filed a big class action involving unlawful people, very similar to what Katie was describing, which is that ICE was pulling people over unlawfully within the community and stopping people unlawfully and arresting without a warrant and in violation of the law. And I don't think we would have been able to do it without a couple of key community organizations who are out in the community and who also run hotlines for family members and were able to help us find plaintiffs because they were talking to the family members of people who were just, horribly distraught because they're a longtime member of the community. Husbands, fathers were picked up and arrested and detained, and oftentimes pretty far from them. So I would just echo Katie's comments to say that is one place, especially when you're trying to react quickly in light of raids or in light of big enforcement actions, that working with community partners is essential to get it done and to get it on file in order to make an impact. So the second sort of illustrative case we want to talk about is involving sanctuary cities. There's been a lot of litigation around sanctuary cities across the country, but I thought I'd keep it quasi-local and talk about one that's close to this area, which is the city of Chicago sued the Department of Justice. So last summer, the Department of Justice announced that for any sanctuary city, they would not get certain law enforcement grants, and these grants were mainly used for stuff. They're used for cars and artillery and various types of stuff that is completely unrelated to immigration enforcement, to immigrants or anything. They're just law enforcement grants that the federal government gives to cities. And so they said, we will not give you these grants unless you can tell us and certify that you're doing three things. You're honoring immigration detainers, you will participate in immigration enforcement, and you will communicate an individual's immigration status to DHS. These things all violated Chicago's sanctuary law, which we call the Welcoming City Ordinance. And because our mayor isn't one to go quietly into the night, the city of Chicago sued Jeff Sessions, the Department of Justice, and said this is unlawful. The district court and the Court of Appeals agreed, and they said that the DOJ conditions attached to those grants were unlawful under the Administrative Procedure Act that we were talking about earlier, and they granted an injunction stopping the Department of Justice from attaching those conditions. They then issued that as a nationwide injunction, so covering all cities. That issue, the scope of the injunction, whether it just applies to the city of Chicago or all cities that are affected, is currently on appeal, but it's sort of a settled issue that these conditions are unlawful. And I think the city of Louisville got one of these letters as well. So this is a big issue, and it was not an insignificant amount of money for they could use the extra funds, and so that was one piece of good news. Katie, do you want to tell us about one of your individual petitions for review?
Sure. Really quick before I go into that, is it's a good intro regarding organizations, community partners who are organizations themselves. Another way that you can be extremely helpful is that when Kate was talking about class action lawsuits, or when you're bringing a lawsuit on behalf of a group of people, one of the real troubles that we see with bringing immigration-related federal litigation is that immigration is very fluid. So somebody may not have a license today, but they might be granted one tomorrow. Somebody may not have a green card today, but they may be granted one tomorrow. And so the legal term is they moot out. They don't have standing to sue anymore because they no longer have the problem for which we are suing. And so one of the ways we remedy that so we can continue and fight these injustices is we ask for organizations to become organizational plaintiffs. And so it's an organization whose members are suffering the type of problems, again, for which we're suing to stop. So that's something else that people who are in organizations can certainly inquire if they would be a good organizational plaintiff in the types of cases that we're talking about. So Nasli had talked about enforcement in the Midwest, and I really appreciate that because I feel like people have always thought, oh, we're Ohio, we don't have a border here, so we don't really get a lot of the enforcement. And if you take nothing else away from anything I say today, please take that is not true. Okay, we have one of the most aggressive ICE offices in the entire country, which is out of Detroit, but it has jurisdiction over Ohio and I think Kentucky as well.
No,
It's just Ohio and Michigan. Yeah. Oh, Kentucky's okay. Sorry, Ohio and Michigan, and they have implemented some of the most aggressive immigration enforcement policies and actions that we've seen since the new administration. We have had two of the biggest raids in the past decade happened in northern Ohio. And another case that I was counsel for was for a woman named Maribel Trujillo-Diaz, and she was one of the first people to be deported under the new administration who had no criminal record, who had 4 U.S. citizen children here, several of whom had varying disabilities. And we fought her case. She came to us after she had been ordered deported. She had a few lawyers for her original case, which she was apprehended in 2007. Filed an asylum application. It was denied at the immigration court, and it was denied at the Board of Immigration. They affirmed the immigration court's denial at the Board of Immigration Appeals. For whatever reason, she at that time did not, file a petition for review at the Sixth Circuit. So we were able to get her prosecutorial discretion based on the previous administration's guidelines because she had so many what we call equities, young children. She'd been here a long time. She was actively involved in her faith community. But then when the new enforcement priorities came out as a result of the new administration, they put her at the front of the line for deportation. We were able to file a petition for review. This case ended up being, it started out as something that, of course, we were doing this because she was our client and we wanted to fight for her, but it ended up being a way to show a lot of people how terrible and heartless this system has become. So we filed for a motion. Some additional things happened to her family back in Mexico that gave her an additional fear of returning home, or to her home country. It wasn't her home anymore. She lived here for a really long time. But we filed a petition for review. We filed a motion to reopen at the Board of Immigration Appeals to reopen her asylum case. And I won't get too technical. I see some people starting to look the other way. So, but arguing changed country conditions because some additional things had happened in her country of origin that, like I said, increased or enhanced her fear of return. The Board of Immigration Appeals basically summarily denied that decision. We submitted hundreds of pages of evidence in support of her fear. We had an expert declaration somebody came in and explained why her fear was valid and why it was substantiated, and corroborated that fear. And the Board of Immigration Appeals was just like, no, I don't think so. I mean, it was like 3 paragraphs, their opinion. And so we filed a petition for review in the Sixth Circuit. Now, as Nasli mentioned, in the Sixth Circuit, if you file a petition for review, you don't get an automatic stay of removal. And unfortunately, Maribel was deported. She was removed to Mexico in April of 2017. However, we filed this petition for review and basically argued that the Board of Immigration Appeals had abused their discretion, that it wasn't fair that they just took all of this evidence and threw it out the window and said, nope, we're not even going to look at it or really consider it. And the Sixth Circuit, talking about the pushback you can get at the federal courts, they actually said, you know what, Board of Immigration Appeals, you need to give us a little more than that. You need to actually look at these 100 pages of evidence these lawyers submitted, including affidavits from people who have firsthand knowledge of why this woman is scared. You need to actually consider this evidence. This is not a rubber stamp. And so they granted the petition for review, and they remanded it back to the Board of Immigration Appeals to decide, to actually look at our evidence, essentially. And they reopened her case. And so now her case is pending at the Cleveland Immigration Court. And we are fighting to get her back in the country so that she can attend her removal proceedings. So she can actually be present to have her own day in court, right? Which is supposed to be one of our fundamental values in our Constitution, is to be able to attend, challenge the people who are trying to present evidence against you and things like that. So there are two things I want to just highlight about this case. The first is, this is public record. You can Google this opinion. And the Sixth Circuit even mentioned in the opinion that they mentioned the sort of covert, underhanded way that Maribel had been apprehended after she'd been going to her check-in meetings. She'd attended her check-in meetings. And they said that they came in between two check-in meetings. She was supposed to attend one in another couple weeks. They came to her house in the middle of the day. They picked her up. They put her in a truck or a van, and they left her 4 children who are all at the time were under the age of 15. They were ranging from ages 3 to 15 in a trailer alone until their father got home for a few hours with no one to care for them. And they mentioned that. So I think that tells us it's not that the court's going to just rule any way you want because they don't necessarily approve of what ICE is doing, but they do take notice of what's happening. And that gave us a little bit of hope that there is somebody out there who's willing to listen. Interestingly, the person who wrote the opinion was a Trump appointee, so I just have to mention that. The second thing, and even more important than that, is that none of this could have happened without the involvement of many, many, many community partners. Like, there are too many for me to list, but the Catholic, the Diocese, St. Julie's, Catholic Charities of Southwest Ohio, a lot of different organizations. We worked with a man named Alan Dickin at PICO, and so we really had a lot of community involvement all over the state, doing vigils for her family, supporting the family, and it really helped not only to, I think, advance the case as far as it got, but also to keep the family in good spirits, because this is, you can imagine, it's just a terrible thing for a family to go through.
And can be a long slog. It can take a long time. I think that's one of the things that it's hard about federal litigation, is that you can get really great results, but sometimes it does take a while. But
it's also costs money.
yes.
Not for Maribel, though. We were pro bono.
So, Katie, do you want to talk a little bit about the Hamama case, which?
Sure. The Hamama cases had, I wouldn't say similar facts, but similar sort of posture to Maribel, in the sense that it dealt with a lot of people who were from Iraq, which is not where Maribel was from, but who had a fear of return that was a result of what we call changed country conditions. So they were ordered removed, and then some things happened in their countries that made them afraid to go home, that they'd not gotten the opportunity to argue that in their original hearings before, in their removal proceedings. So these were all a group of people with removal orders or deportation orders. And the ACLU in Detroit, I believe, I think it was the Detroit office specifically that brought this litigation. They filed for what we call injunctive relief, which is the lawyer term, the legal term for stopping something. So they filed to, first of all, these men were detained and they were about to be deported, and they filed to enjoin their deportations, to stay their removals, so that they would have time to file motions to reopen, like to sort of allege kind of what we did with Maribel's case, to present the new evidence, present the evidence of changed circumstances, to argue why they have this new fear of being deported. And then they also filed for injunctive relief. So first the stay was granted. So all these people were told they were not going to get deported. They were going to have a chance to have their day in court, to file these motions to reopen. But then these people were detained for a really long time. As Nazli mentioned, it takes, or I can't remember who mentioned it, but somebody said, it takes forever. And these cases take a really, really long time to go through the court systems. Meanwhile, all these people are still sitting in detention. So they filed another for injunctive relief to get them to have bond hearings. So what I understand is about half of them have been released on bond, I believe.
I think that's right, yeah.
And the interesting thing about the Hamama case, well, there are a lot of interesting things, but one of the things is this that we've been seeing, we saw it with the Daca litigation, is this notion that's fairly new, or at least it's become more common, that you can file a case for injunctive relief to stop a federal government action or program or process or priority, whatever, in one court, in one division of one state, as long as it's a federal court, and it has implications for the entire country. So, you file this one case, and now everybody who falls into that category is now, basically it gets to benefit from this one ruling. Or in the early DACA administration, the Daca litigation, does not benefit. We all from that case. So that's been something that I think has been really interesting and sort of a newer tactic, or if it's not new, it's certainly been used more lately.
And probably the most well-known example of that is in the travel ban litigation,
Yes.
where judges were saying, listen, this is one policy that covers everyone in the country, so the District of Hawaii is going to enter an injunction that is going to cover the whole United States, which the Supreme Court was kind of skeptical of. Justice Gorsuch called it a cosmic injunction, and not favorably. I thought that sounded really cool. Like, let's have more cosmic injunctions. But that's what's actually on appeal right now in the Chicago sanctuary city case right now is not whether the injunction was correct. The Seventh Circuit says it was, but the scope of it. So, yeah, more to come on that. So exciting. So speaking of DACA, I thought this doesn't really pertain, these cases aren't happening here in the Midwest, but because so many of you I know work with people with DACA, and these cases, again, involve cosmic nationwide injunctions, we just wanted to highlight what's going on with the DACA litigation. So there were 2 cases filed, there have been 3 cases filed, California, New York, and DC. And the California and New York cases came out substantially the same. Again, going back to that very useful Administrative Procedure Act, the courts found that the Department of Homeland Security just didn't give good reasons as to why it was rescinding DACA. And they said administrative agencies have to articulate good reasons. And so they put the rescission of DACA on hold. And what that meant is they could still accept renewal applications. Then the DC case, they said the same thing. It was, the fancy legal term is arbitrary and capricious. And they vacated the rescission. But the tricky thing with this case is they said, we're going to put off this decision for 90 days, and we're going to give the Department of Homeland Security another shot to issue an order ending DACA, which 2 weeks ago, the Department of Homeland Security did. So now we're going to be in a new round of litigation as to whether they did it right the second time. So it was really unfortunate that this court essentially gave DHS a do-over on their rescission order, because it was pretty bad the first time, and we were hoping it would just stay bad. So there will be a lot more litigation on that issue to come. So we're going to talk a little bit more about organizing strategies and working with law enforcement.
Sure. So before I became a staff attorney at ABLE, I was an Equal Justice Works Fellow, and I did a lot of work with local law enforcement agencies on immigrant-friendly policing policies. Jessica Ramos, a colleague of mine, also in the Dayton office at ABLE, has done a lot of work with the city of Dayton, Dayton's police department too. I think it's important to remember that not every single law enforcement agency is out to get immigrants, and it's really important to build on partnerships with those who are willing to work with immigrants, particularly immigrant victims of crime, to encourage people to still come forward and report crime, because of course that keeps us all safe. And we're all safer when people who are victims of crime are reporting those crimes. There are also some really great immigration benefits that you can get people, like a U visa or a T visa. And we don't have time to go into all of that right now. There are 3 main things that I have focused on my training with law enforcement. The first is to talk to them about immigration in general. One of my first trainings I ever did as a fellow, the chief of this fairly large suburb came up to me afterwards and was like, "Hey, I'm really glad you gave that training. I had no idea being in the U.S. without status wasn't a crime." And I was like, "I'm really glad I did that training too, because that's really good that your police workforce knows that now. So they think, and talking to them about sort of where they're restricted, and you get to control that narrative if you're the person in their training. It's a very little touchy area if you're not a lawyer to be giving that to be educating people on legal issues. But as community partners, you can certainly have meetings with your local police or sheriff's offices and talk to them about, issues that you're seeing in the community. And you frankly will have more pull if you live in that community than some lawyer coming in from another city talking to them. We also talked a lot I also train and discuss U visa and T visa certification policies for victims of certain serious crimes and human trafficking. And then also language access, so getting interpreters for people, both victims and suspects of crime. And there's a whole presentation we could do on interpretation issues at court and other things. And so continuing to work with your local communities and the governments, the local justice system on developing these policies can be a way that we can still not just fight back, but actually make good inroads for our immigrant communities.
And if I could jump in, language access is a civil rights obligation on the part of any federally funded agency, and that includes state agencies. So they are required to provide language access. And I think that's an area where we could be doing a little bit more litigation, or at least challenging the policies that exist, especially in local areas.
And I think it's especially important for people who speak indigenous languages. So, it might not be as critical of an issue for Spanish speakers, but for those that speak only an indigenous language or just a language that is a little bit more rare, it can be very difficult, even in immigration court, where you would expect there'd be a lot of interpreters.
And we have seen several cases here in Hamilton County Court, actually, where the individuals were charged with resisting arrest or something else just because of the language issue.
Oh, wow. And oops, there's nothing on this slide. Wait, hold on, let me see. Okay, let's, it's just a blank mystery. So we're talking a little bit about detainer policies in sanctuary cities. Enid, could you tell us a little bit about the advocacy that went into Louisville's law?
Well, so Louisville has a welcoming city ordinance, which I know a lot of our advocates in the room would call Sanctuary City Light, but it did actually make a difference in the city. And I would say the organizing strategy that occurred was there was a media expose on the collaboration of ICE with local law enforcement, and we had been having community meetings with the mayor and the head of the mayor's globalization officer and the chief of police, who said, "Oh, we're absolutely not cooperating, only when we're executing warrants that are for dangerous people who have committed crimes." And so once we had this documented publication, it really moved forward the advocacy efforts that were already ongoing. So there had been regular presentations made before our Metro Council, monthly advocacy statements by different organizations advocating for a welcoming city ordinance. And so I would say that together, the media strategy, the media highlighting the issue that was actually happening that we'd been complaining about for a year in our private meetings or semi-public meetings with the mayor's office really led to the momentum where the Metro Council and the city of Louisville was forced to take action because of all of the work that had gone behind the scenes. So it was really a great, effective strategy, and we were lucky to have the media expose happen right at the time, and that really was the final push.
I'm gonna add on Cincinnati, Kate. So Cincinnati is not a really sanctuary city. We don't have a proclamation. We don't have an ordinance. We only have a proclamation. So it's a little bit different here.
And what is the difference between a proclamation and an ordinance?
Proclamation is I really can't tell you the difference. Well, it's not, I guess, on the books.
Right.
So, but it's something that mayor just came out and say that, Cincinnati is a sanctuary city, but there's no enforcement behind it. We don't have it. It's not a written policy.
Yeah.
It's more like guidance, not a legal obligation, right? So arguably the ordinance is required action on the part of, and it only applies to Metro Police. So we have a big problem with Metro Corrections, which is the jailer, who is still collaborating, communicating with ICE when they release individuals, who is also under the mayor's jurisdiction. So that's our next effort at advocacy. But the ordinance at least provides the opportunity to go back in and talk to the mayor's office and make sure that they are complying and ask for reports, and it's effective law.
And here it's a little bit different. Cincinnati does not have its own jail, and it's a county jail, and sheriff is not under the mayor, and sheriff does cooperate with ICE. So anyone who's Cincinnati police, while they saying we do not call ICE on someone, but anyone they detain and put into the county jail, and it's not just Cincinnati. We're talking about Sharonville, Evendale, Glendale, and any other smaller cities and villages in the greater Cincinnati area. Anyone who ends up in Hamilton County Jail gets called ICE.
If I can just make one more plug for Public Records Act requests, because one of the things you can do, because we have that in Dayton too, so Montgomery County, we have a fairly, he probably would, immigrant-friendly police in Dayton. Not so much with the sheriff of Montgomery County. But if you do Public Records Act requests, you can figure out sometimes, well, you should be able to figure out who's being referred to ICE and what the arrests are for. So one way to try to get at that is to figure out, are people being arrested because of a no operator's license violation, which they're really not supposed to do that for a first-time offense, at least in Ohio. But in trying to figure out how people are getting into the jail to begin with. So if you do have a police agency that's maybe more willing and responsive, potentially working with them on policies as to like when they make those arrests, because it's when we could have a whole day on sanctuary city or on secure communities, but it's when they actually arrest somebody and run their fingerprints and get them booked that we start immigration enforcement really gets involved, other than if they're just going to call them on the side of the road, which also happens sometimes.
Yeah, and so can you all describe, so after that point, and at the point in which they're in a county or city jail, what is the communication with ICE, and what happens when there's not these laws against holding people? Can you all describe what a detainer is and what the effect of that is?
Yeah.
Or
Okay, that's
yeah.
me. Sorry. So detainers are it's an administrative document that's issued by ICE asking for local law enforcement agency to hold a person for up to 48 hours, and it can be longer if it's over the course of a weekend. And it is just a request. It is not a requirement. It's not mandatory, and there's a lot of confusion about that, whether an administrative request to hold someone who could be subject to immigration, who could be detained by ICE, is legally enforceable. It's not. And so what we find, though, is that there is a lot of misunderstanding. The ICE can issue a detainer asking local law enforcement to hold someone. They can issue a warrant saying they have reason to believe that someone has committed an immigration violation. But neither of those documents have been reviewed by a judge. They are not authority for local law enforcement agency to enforce. And so when there's collaboration between local law enforcement and ICE in executing warrants, or that's a problem, because local law enforcement has no authority to even be involved in federal immigration enforcement, so should not be involved in working with ICE on executing those warrants. That's a federal immigration law issue. So that's one issue that comes up. And sometimes the arrest warrants, they appear to seem to have greater enforcement authority, but again, they're not reviewed by a judge. There's no independent determination that there is actually some probable cause to believe someone has violated immigration law. And immigration law is a civil law system, so it's a civil violation, and hence another reason why local law enforcement really should not be involved in enforcing federal law. But there is a limited authority for local law enforcement to be involved in enforcing federal criminal law, but not most of the system is a civil law system, so there's no rationale for local law enforcement to be involved in that.
And I think, go ahead.
Oh, I'm sorry. And what we found a lot of times through the FOIA request, sometimes those are not even signed by anyone, period. So sometimes even ICE themselves, the agency, there's no one signing that detention order. So detention request.
Right.
I think someone at AILA, it's American Immigration Lawyers Association, said that the paper on which the request is typed up actually worth more than request itself. So.
Yeah, and I think, probably most of the people in this room don't want their local law enforcement in the business of ICE enforcement. But one of the things that we've been trying to communicate to county boards of supervisors and organizations that are grappling or local organizations that are grappling with sanctuary policies is that it's also an expensive business because, as you might imagine, ICE sometimes makes mistakes and might send a detainer and a warrant for somebody who is a U.S. citizen or otherwise should not be subject to that detainer. And as a result, there have been many cases, going back to litigation, there have been many cases where these counties and cities have to pay thousands and thousands of dollars to settle lawsuits because they have detained a U.S. citizen. And because, as Enid said, ICE really doesn't have the authority, the local jail is still on the hook for that 48 hours or however long that they're holding that individual. So they are legally liable if they get it wrong. So again, there's a lot of confusion about what that document really does and what that document says and what that document authorizes. And one small pitch for NIJC, we have some materials that we've been sending out to local governments to explain all of this and to explain what detainers are about and sort of the liability that comes with them. So if any of you are working with your local governments, I'd be happy to send those materials along to you. So, and then let's talk a little bit about fighting immigration detention, also sort of related to this. But Katie, do you want to talk about bond hearing projects?
Sure. Full disclosure, I don't head this project at ABLE. My colleague Emily Brown has created a project with Ohio State University's Civil Clinic where she works with law students there to provide, and in collaboration with the Immigrant Worker Project, to represent detainees almost always at Seneca County Jail, which has one of the local contracts with ICE. And represent them in their bond hearings. So this kind of gets into a larger conversation that we have had in our planning conversations about the way things have changed for us as litigators and for us as for those of us who work in nonprofits with limited resources. So if you have, like we had in these raids where you have, in the 2 raids, somewhere around 250 people that were apprehended. Not all of them were arrested and actually booked into detention, but you have quite a few people, and one of the big things is if you can get someone out on bond, that's a big impact for them because they now are not going to be detained. When you're detained, your case is expedited, so it goes much more quickly. And so if you can get somebody out on bond, they then have a lot more time to prepare their case, to get the documents, to hire a lawyer, to work to pay a private attorney if there are no pro bono attorneys or they don't qualify for services. And so that's a sort of a plug for that project. Law schools can collaborate. Volunteers are crucial because if somebody's detained, they can't go get letters of support or find their passport to bring to you so you can, copy it and send it to the court or whatever. So that's an area of community collaboration that's very needed. And then another big change that we're seeing with fighting immigration detention deals a lot with just pushing back. I mentioned that Ohio and Michigan to some extent as well, we've really been targeted in the past few months, and I would even argue in the past year and a half. We've really been ground zero in some ways, aside from the border, for some of these really harsh anti-immigrant policies. And there are a lot of reasons we could discuss as to why that is, but the bottom line is it's happening. And one of the things that we have to show is that, I believe, and I think a lot of people would agree, that ICE is really into numbers. This is a numbers game for them, and they're going after communities that they think can't fight back, where they're going to be able to deport a lot of people, get really good numbers for them, and pat themselves on the back at the end of the day and say, we're making this zero tolerance policy happen. That's not really, but anyway. And so, universal representation has become something that people are really talking about now, and that means making sure everybody has a lawyer, as many people as possible, the goal being everybody. And it could be everybody who's detained getting a lawyer so they can get out on bond or they can have the best chance. And so that's where, organizations that are able to provide, some people are able to hire private attorneys, and that's wonderful, but a lot of people may not have a lot of family, or they may have a big family and they don't have those resources. So for pro bono attorneys donating their time, volunteers donating their time, or for people to help contribute financial resources to organizations like ABLE or NIJC who are doing that work is really, really important, so that we can try to make sure everyone has a lawyer.
And
Go ahead.
I'm sorry. Real example of some of you who went to Butler County yesterday and visited our detention facility here. So normally we would have on a bond hearings about 20 to 25 people who sees the immigration judge per day, and I would say on average only 20% are represented. 80% do not have an attorneys because or A, they cannot afford it, or they weren't able to be eligible for the free representation or some other issues. But it's a very, very small number, 20% on average of people who are represented. And having an attorney versus not having an attorney on those during the bond hearings makes such a huge difference. So it's very important, and I would echo what Kathleen said with the funding. Do support your local organizations, and hopefully we'll see more representation in locally Butler, Boone County. There has been also a huge enforcement in northern Kentucky by us.
And I would say this is an area where criminal lawyers who have no immigration law expertise can get involved, because bond hearings are just the regular kinds of concerns about flight risk, likelihood of showing up at a hearing in the future. And we've done something through our law school at University of Louisville where we have an externship placement where students are working, it's only 1 or 2 students, but are working with the local immigration attorney, and I'm supervising them, and they're doing telephonic bond hearings. So there are lots of different ways to bring people to help, and we're matching students who speak Spanish with attorneys who don't, so more criminal law attorneys can get involved. So there's a lot of need for community organizations to help think about how to ensure there's wider representation.
That's great. And then the last thing we're going to talk about is just as you may have read in the whole context of the family detention issue, ICE is trying to build more and more detention centers and trying to enter more and more contracts with existing centers like county detention centers. So we thought we'd give an example here. I know there's some people in the room that worked on this campaign, but in Elkhart, CoreCivic, which is one of the major detention, immigrant prison pipeline private companies, plan to build a detention center in Elkhart, Indiana, and there was a group of organizers that really resisted that, and they ended up pulling out of that contract or out of the negotiations. And so I think we saw this also happened out in Idaho, and I think that it really shows that a group of committed organizers can really start to create pressure on the system and slow down the detention pipeline. So that is all that we have. Does anybody have questions, comments, suggestions? Oh, that's awkward. Yes.
Sort of a different topic, but kind of the same. I feel like, our checks and balances right now are, we have none, basically, except for the courts. And the courts are only about check and balance if you use them. So I feel personally that they're what's saving, you guys are what is saving our country right now. And number one, and just as a comment, and number two, how do you feel the placement of Trump's ideology, the lawyers that have this ideology of changing what you're doing? Or do you see, because they're trying, while they're distracting us over here, and they're just putting as many judges in place. And I'm just wondering, do you see like a change in
The judges.
the judgments that are happening?
So I'm just going to repeat the question so that everyone in the room can hear it. So the question is, what is the effect of Trump's lawyers and the people he works with, and how is their placement affecting the work that we do, especially you're saying judges and other types of lawyers? How does that affect what we're seeing in the work we do? Is that accurate? Okay. The one thing I will say, and I used to work for the government, so I think one of the things that I have seen is that kind of the worker bee attorneys who might not have such an ideological bend tend to have less discretion right now and less control of their cases, and that there's a much more top-down environment, such that the people who do have more of the ideology or maybe the harsher opinions of immigrants, or they tend to have more control than they might have in previous administrations, where the typical line attorney might have more control and discretion over his or her docket. So that's one thing I've observed.
Yeah, there's a lot of stress among the government attorneys also, and it's kind of a joke, but also not a joke. The good government attorneys were told that if you don't enforce this, you're gonna get fired. That's like ongoing conversation. So, but yes, definitely less discretion that's given not just to the attorneys, but also immigration judges.
Yeah.
This is in national headlines. So judges are losing their authority. For example, granting the administrative closures, which is really a continuance for longer time and nothing more, but that's been taken away from them.
Well, in Ohio, a lot of our federal court judges, so Nancy was talking about administrative immigration judges. The reality is, in a lot of our courts, they were already very conservative. And so the fact that there are the newer judges are appointed by Trump, what my personal experience, and I don't know what you would say, I think, I haven't, it's not like I have a case pending in every single court in front of every judge, but I think some of the things that are happening against immigrants are so outrageously, violative of our Constitution that even the really conservative judges are just like, we get rulings in our favor sometimes from them too. Not all the time, but sometimes.
Right, defending the rule of law. I mean, that's how the courts have made a difference in the fight against the Trump administration policy. So, both conservative, regardless of who appointed them.
Yes.
I want to on Maribel Trujillo-Diaz. Not only, you know the case so well, you briefed and argued it and won it. And the judge that wrote the opinion is not only a Trump appointee, but he happened to have the name of Bush, Judge John K. Bush. Nothing to do with the presidents, but the Republican presidents. But this is the point here is judges have a conscience. ICE agents have a conscience. The soul of America. We are all Americans. Some judges, will, like Judge Bush gave you the decision. And ICE agents, I've seen them in the field, some of them will help you, even if at the risk of their careers. You need to know who are helpful and who are the gunslingers. This is all part of our experience and what we do. So be vigilant, be sensitive to who your friends and allies are, even within ICE, within USCIS, and in the community. So thank you so much.
That's good advice.
Thank you all. Are there any further questions?
I'd like to say one thing. I'm the only one who's not a litigator on the panel, and so when I was an immigration lawyer before I became a law professor, we did everything we could to avoid going to federal court. So these women here who are going to federal court and everyone else who's out here who's a litigator, I applaud all of you because it's the work that is making a difference. So thank you.
Our time is about up. We'll stay up here for a few minutes because I know there's a few more questions, but I also don't want to keep anyone past the time since we are the last session of the day. So we'll hang out up here and feel free to come up and we can keep the discussion going. Oh, one more. Okay, yeah.
Gracias por todo lo que nos compartieron. Es importante, es como una observación. Cuando se hagan entrenamientos de conocer sus derechos en la comunidad, como abogados es importante no enfocarse en casos específicos, sino este tipo de educación es la que necesitamos en la comunidad.
So thank you for all you've informed us about. I wanted to, just as an observation, point out that when Know Your Rights trainings are done in the communities, it's important not just to focus on particular cases, but on general cases or general law.
Y bueno, en un caso que hubo con uno de nuestros miembros nos dimos cuenta de eso. Es cuando hay un caso, por ejemplo, en el área que trabajamos de Workers' Compensation, usted necesita un abogado y necesita un doctor. Entonces, esta puede ser una fórmula muy poderosa, un abogado trabajando con la comunidad. ¿Por qué razón? Porque hemos visto en las cortes, en este caso, están vacías, no hay presión para ellos. Entonces, el trabajo de la comunidad aliada puede ser eso, llenar las cortes y meter presión para que se resuelvan los casos en favor nuestro.
So I'll compress it a little bit, but one thing is we had a member who was in deportation proceedings, and just looking at the way in which workers' comp works, in which there's a doctor and a lawyer, we can think of the when we go to these courtrooms, sometimes they're empty, and we had in the case of our member, we filled a courtroom several times, an immigration courtroom, and that's a role that the organizations could have to support immigrants is to make an appearance, to be in support in the courtrooms themselves.
And if I can just say one thing about that, when we filed our raids lawsuit a couple months ago, we worked with a community organizing partner, and they brought throngs of people to the courtroom. And we were able to show the judge, and the judge had to see the families that were affected by people in their community being picked up. So I could not agree more that filling courtrooms and getting people so that judges understand who they're talking about, especially if you're going to federal court as opposed to immigration court, where federal judges aren't used to seeing the community coming out as a whole.
Actually, in immigration court also, it's very important to have the communities in. It's very interesting. So I've recently been to Chicago Immigration Court, and I found out that they have Interface Court Watchers organization, which is great, and they come and they observe the hearings, and that's really makes judges and also DHS attorneys, the government attorneys, behave towards the clients and defending attorneys, but it really does make a difference. And unfortunately, here in Cincinnati, our immigration court is in Cleveland. And another closest one is Louisville, Kentucky. But if people are interested, or the organizations have partner organizations in those cities and can arrange for others to come to the hearings, that would play a big role in helping some immigration cases.
Obligatory lawyer disclaimer, though. You should talk to the attorney who's representing that person, because some judges really don't like that, especially immigration judges. And so it's really dependent on the case and on what you're asking, and also on who's coming. So I would just always touch base with the attorney before bringing a bunch of people to court. It also may not be safe to bring undocumented people to certain types of courts, so you just have to be really careful.
Well, thank you all. And we'll stay up here for a few minutes if there are any other questions.